Hi, I'm Greg Corombos. Welcome to Banking Compliance Insights by Wolters Kluwer, a podcast series from Wolters Kluwer. This series was created to deliver insights on compliance trends and strategies for navigating today's regulatory and risk environments. Today's episode, Update and Current Status of IRAs, What Has Changed and What You Need to Know, will focus on adapting banking processes and client outreach in the current environment. Here to lead our discussion on this subject is Wolters Kluwer Vice President for Banking Compliance Solutions, Samir Agarwal. And he is joined today by Michael Schiller, a manager of specialized consulting for tax-advantaged accounts with Wolters Kluwer's Compliance Center of Excellence. Samir, let me pass the conversation over to you.
Thank you, Greg. Since December of 2019, there has been a significant amount of activity as it relates to IRAs and tax-advantaged accounts, including the Secure Act, setting every community up for Retirement and Enhancement Act of 2019, and the CARES Act, Coronavirus Aid, Relief, and Economic Security Act. Today, we've asked Mike, an IRA and tax-advantaged account subject matter expert from the Wolters Kluwer Compliance Center of Excellence, to join us. He is here to help us step through and understand the provisions within these pieces of legislation and describe the impact that they have on us. He's going to share some of the practical guidance for bankers and managing tax-advantaged accounts. Welcome, Mike. Tell us a little bit about your day-to-day and what you do at Wolters Kluwer.
Thank you, Samir. I have actually been with Wolters Kluwer for nearly 25 years, initially working in the sales area, and since 1997 in the tax-advantaged accounts area, originally as an IRA consultant, where we specialize in assisting financial organizations with all of their tax-advantaged accounts needs. So essentially, we primarily work with individual retirement accounts or IRAs, health savings accounts or HSAs, small business plans like simplified employee pensions and savings incentive match plans, as well as Coverdell education savings accounts. I've been in a management role now for just over a year, and our team of consultants, of which there are 5 of us, answer telephone calls over our consulting service for financial organizations. And we also do an extensive amount of on-demand or pre-recorded training. So that essentially sums up what I do and a little bit of my experience with Wolters Kluwer. As you had mentioned, there have been some significant legislative changes since December of last year. The IRA-related changes apply to those accounts owned both by individuals and those that have been inherited by a beneficiary as the result of an IRA owner's death. The IRA owner-related changes apply mainly to those individuals who are near or at retirement. So with that in mind, let's consider some demographics, especially that segment of our population referred to as the baby boomers. This is the generation of people born between 1945 and 1965, as I think everybody knows, but that portion of our population is 77 million people strong. So from an age standpoint, the leading edge of this generation is now in their early 70s, and they expect that their IRA trustee or custodian understands the rules and is administering their IRA as expected.
That's an interesting point, Mike. So in this Secure Act, I noticed that there's a lot of provisions that affect IRA owners at that age. Can you just talk about some of the provisions and what those changes are?
Well, absolutely. First, the age at which traditional IRA owners must begin taking required minimum distributions, or RMDs, from their IRAs has been moved back. So anyone that was not age 70 and a half by the end of 2019 can wait until the year they attain age 72 before having to begin taking traditional IRA RMDs. Another Secure Act-related change that applies to individuals in this age segment of our population is that beginning for tax year 2020, there's no longer an age restriction to make a traditional IRA regular contribution.
There's 2 things that you're saying there that I want to dig in on. One is, if I was planning to retire at age 70 and a half, and now it's age 72, are there any requirements that the bank needs to do to notify me, or does the IRS notify me, or how do I get to know that? Let's say I'm just a regular consumer that's not really necessarily watching the news or the financial regulations very closely.
The IRS actually has released some information on what it has in mind as far as making IRA owners aware of the fact that these rules have changed. However, those indications aren't anything, or those requirements aren't anything that need to be acted on immediately. And I'll discuss some of what a latent notice by the IRS indicates and what the amendment requirements might be. But in short, at this point, the best way for financial institutions to inform their IRA owners of the changes is to educate them. And that's either going to be through conversation or a lobby brochure or something to that effect. But it's absolutely critical that IRA owners are made aware of the changes because right now their IRA plan documents really don't reflect the current rules in many cases.
The second thing that you were talking about was removing an age restriction. That age restriction, what guidance is there on that? Can I make contributions even if I'm taking distribution? Or is it really you're either in one mode where it doesn't matter how old you are until you start taking distributions, you can still contribute?
And that's actually a very interesting observation. Under the old rules, pre-Secure Act rules, actually, the way it worked is the year an individual attained age 70 and a half was the year they could no longer make regular contributions. It was that year for which they had to begin taking distributions. So prior to 2020, the old rules applied, pre-Secure Act rules, if you will. Again, mandatory distributions had to start upon an individual attaining age 70 and a half, and they could no longer make regular contributions. So, one of the things, though, with this change is that if an individual wants to continue to make regular contributions after attainment of age 70 and a half, now they still need to have compensation. That has always been a requirement, so that rule has not changed. In addition to the changes the Secure Act, has made by IRAs owned by individuals, we should also really think about the changes that have been made to inherited IRAs. More specifically, the Secure Act created a new classification of beneficiaries, Samir, referred to as an eligible designated beneficiary. So it's, in this case, essential to point out that upon the death of an IRA owner, depending on how a beneficiary is categorized, an individual who inherits an IRA after 2019 will either be classified as, again, what the Secure Act rule calls an eligible designated beneficiary, or let's say just a designated beneficiary.
There's a distinction there, Mike, and I want to be very clear so it doesn't get muddy for our listeners. Before we go over the designated eligible beneficiary, let's go over the basics on what designated beneficiary really means.
A designated beneficiary is a beneficiary that has a life expectancy from which they can take distributions. That's at least under the old rules. An eligible designated beneficiary going forward is the only type of individual that can take distributions using life expectancy. So, in other words, when we talk about designated beneficiaries and eligible designated beneficiaries, I know we're talking semantics here, but we need to differentiate that from, let's say, a person or an individual or an entity that is a named beneficiary. So anything or anyone can be a named beneficiary that inherits assets from an IRA upon an IRA owner's death. But if it's an individual versus a non-individual, like a charitable organization or an estate or something like that, if it's an individual, that's where a distinction is made between an eligible designated beneficiary who essentially still has the options available that they did under the old rules versus, as I said, just a designated beneficiary. Now, when we talk about an eligible designated beneficiary, those are individuals who are going to be given, let's say, special treatment. They can still take distributions using their life expectancy, which essentially is going to extend the distribution period. And that would include the IRA owner's spouse, the IRA owner's minor child, or someone who is chronically ill or disabled, or any other individual who is not more than 10 years younger than the IRA owner.
Okay, so that preserves the tax advantage portion if you fall into that category, right?
I think that's a fair statement. Absolutely. Okay. Because, again, it's generally going to extend the distribution period for that group of beneficiaries. Again, if they want to use life expectancy. Now, the designated beneficiary classification of individuals, so let's say an example would be an IRA owner's adult child, would not have all of the options available like life expectancy and those things. That's a case where the 10-year rule applies. And the 10-year rule is actually a new provision under the Secure Act. So, we look at the beneficiaries that are more restricted and may not have that tax advantage like you just indicated. Those are, again, individuals who are referred to as a designated beneficiary. Again, the 10-year rule is essentially what their option is going to be unless they want to take a lump sum death distribution at any time. And this provision also applies to certain trusts.
What are the actual terms of the 10-year rule?
Under the old rules, pre-Secure Act rules, I should say, there was this provision called the 5-year rule. And the 5-year rule for individuals no longer exists. But I want to draw a parallel to that because under the 5-year rule, if an individual was subject to distributing money under that provision or assets from an IRA, they could take as little or as much as they wanted during a 5-year period, as long as, again, the balance of the IRA was fully withdrawn at the end of the 5th year after the IRA owner's death. Now, we kind of assume the 10-year rule is going to work the same way, but the tax law has this 10-year rule provision written in. The IRS, however, at this point has not defined what they vision as the 10-year rule. It is very likely a case where a beneficiary will probably be able to take as much or as little out of an inherited IRA as they want during that 10-year period, or they may choose to not take anything until the end of the 10th year at all if they don't want to. But again, we can't definitively say that until the IRS comes out with regulations defining it more specifically.
Yeah, and I think that makes a huge, huge impact to those that are either, giving inheritance to family members or designated beneficiaries or eligible designated beneficiaries in this case, and just wealth management in general, right? I mean, now you're being forced within a 10-year period, which sounds good if it's up from the 5-year, but what happens if you miss the window? What if you go beyond 10 years? Are there penalties involved, or do we anticipate penalties?
Yeah, very interesting question. The tax law and regulations are very specific as far as penalties regarding an individual's failure to take a distribution timely. Of course, the IRS is in business to collect tax revenue. And when we look at traditional IRAs, those accounts are maintaining a whole lot of tax-deferred earnings. And in the case of deductions that were taken at the time of regular contributions, that money is waiting to be taxed as well. So in the old world, pre-Secure Act rules, I should say, under the 5-year rule, if money wasn't withdrawn by the end of the 5th year, there was a potential for a 50% penalty on the balance of the IRA. So assumably, it's probably going to be the same thing with the 10-year rule. And I shouldn't say assumably, it's more than likely because the tax law basically is written in that manner. Anybody who fails or if a distribution is not taken timely, a 50% penalty tax applies. So and that's something that an IRA owner has to have a discussion about with his or her accountant. So yes, to answer your question in short, there are absolutely penalties for failing to distribute assets from an IRA timely, whether it be an IRA owner while living or a beneficiary after the death of an account owner.
Wow, that's really harsh. Are there any provisions that relate to an IRA to IRA transfer where penalties may not be there or avoidance of distribution rules?
An individual, whether it be an IRA owner or a beneficiary, certainly can transfer IRA assets anytime they want. However, they need to be very aware of the fact that, if a required distribution is due, that they can't get by from having to take that required distribution by just transferring to another financial organization. Whether the money is maintained with one institution the entire year or somebody transfers partway through the year, the required minimum distribution is still something that needs to be taken by the end of the year to avoid, as we discussed earlier, any potential penalties. One of the other things that is worth mentioning, and this rule has not changed either, is, a non-spouse beneficiary who inherits an IRA needs to continue taking death distributions, using whichever rule applies, whether they're an eligible designated beneficiary and they have the life expectancy option, or they're subject to the 10-year rule as a designated beneficiary. So the bottom line is a non-spouse beneficiary cannot transfer money into their own IRA. They're subject to the inherited or beneficiary IRA rules.
Some pretty significant changes. Are there any other exceptions that you wanted to call out or help us understand?
there is one other thing, I guess, that is worth mentioning, and that's, for people that are interested in helping or using their IRA to pay for birth or adoption expenses. There's a provision that allows a $5,000 penalty-free distribution. It's an aggregate, though, so if somebody has multiple IRAs, they can only take the total from the different IRAs they own. In a case where our two parents each is eligible to take up to $5,000 for, again, qualified birth or adoption expenses. Now, another interesting part of this provision is the fact that they can repay these distributions under certain circumstances.
I want to shift gears just a tad. Let's go to the CARES Act and understand some of the shift and what that means for the IRA and tax advantage accounts. So same thing. Let's kind of walk through the provisions that have impacted the same set of accounts from CARES.
Yeah, absolutely. The CARES Act was a pretty significant piece of legislation in and of itself. Interestingly enough, had we just received, the Secure Act or the CARES Act, one or the other, we would have been busy updating all of our products and everything. But the CARES Act rolls around, it's passed by the president or signed into law by the president in March. The first thing I think is worth mentioning is very significant in 2020, and that's the fact that nobody is required to take a distribution from their IRA this year, whether it be an IRA owner or a beneficiary who has inherited an IRA. So required distributions are essentially waived for all of 2020.
There's two things that concern me about that. So one is, what impact does that have to banking systems or the ability to administer those accounts? And then two, if I am somebody who wants to take advantage of this situation, is it really an advantage, or do you anticipate in 2021 then I'm going to have to take that distribution anyway, or is it really just a deferred distribution? You never have to take it in 2020 and you go about to your regular distribution in 2021.
Great questions. So first, impact on data systems. A lot of individuals, whether it be IRA owners or beneficiaries, ask financial organizations to set up auto distributions. And we took a lot of calls as soon as the CARES Act was passed. When I say we took a lot of calls, the Tax Advantage Accounts consulting team over our consulting service has taken a lot of calls regarding, what an organization does if an individual's required distribution went out, because that's how their data system was set, was to send it out. And the IRS actually addressed in a notification that they were eligible to bring that money back. So financial institutions, did have a lot of, I don't want to say rework, but there was a lot of extra administrative work that they were doing as a result of auto distributions being paid out and then being brought back by IRA owners and beneficiaries. So from a data system standpoint, I think most of that is now behind us. Can't say for certain. And then the other question you had is, regarding their waived required distribution for 2020. It is waived. Nobody has to take it. 2021 starts the new year, so anybody that is in distribution in 2021 will basically pick up from where they left off in 2019. Nothing has to be taken at all in 2020. I want to clarify a little bit more on the ability for an IRA owner or a beneficiary to bring that money back and redeposit it to an IRA. So the tax law says that a required minimum distribution is not eligible for rollover. Well, because the CARES Act waives required distributions for 2020, these withdrawals aren't classified as required distributions. So therefore, there isn't really a conflict in the law. The interesting thing, though, that I think is worth mentioning is the fact that non-spouse beneficiaries have been given the ability to return or bring back as a rollover a death distribution that had been paid out. And this is the first time I can remember in my 25 years of experience working with IRAs that the non-spouse could actually bring money back and roll it into an IRA. So they've been given some extra consideration this year as well.
Help me understand that just a little bit more. So in this case, a non-spouse beneficiary takes a distribution from a mandatory perspective, let's say 2019. In 2020, they can take those funds and essentially just roll them over into a new fund?
Yeah, only 2020 required distributions are eligible for redeposit as a rollover.
Because they're not required, right?
Well, it's a little bit more than that for beneficiaries. Non-spouse beneficiary is never allowed under the tax law to complete a rollover of any death distribution amount, whether it be a required distribution amount or any amount greater than that. So a non-spouse beneficiary under the tax law cannot do a rollover. But because COVID-19, because the CARES Act waived required distributions, because a lot of those distributions had been auto-paid out, the IRS came out and said, okay, here's what we're going to do in 2020. For 2020 distributions only, we're going to allow IRA owners to bring back their required minimum distributions, and we're going to allow non-spouse beneficiaries to do the same thing. But this is the only time, like I said, that has happened. Now, IRA owners generally who take distributions can redeposit them as a rollover, with the exception of a required distribution under normal circumstances. But again, this year is anything but normal, so anything can be rolled back up to the required distribution amount only.
Tell me more, Mike. What about Roths?
Under the CARES Act, in addition to the fact that IRA owners and beneficiaries don't have to take required distributions, it does create an interesting scenario for an IRA owner who wants to convert money to a Roth IRA. You know, the purpose of doing a conversion is obviously tax strategy. It's going to cost an individual tax liability up front. You know, on the traditional IRA distribution side, they put the money in the Roth IRA as a conversion contribution, and then they potentially reap the benefit of tax-free earnings after a 5-year taxable or holding period. So the interesting thing under the tax law is that an individual who is in mandatory distribution status, and this is IRA owners only, it does not apply to beneficiaries. So if an IRA owner wishes to convert a traditional IRA to a Roth IRA, they can do so. But if they're in distribution status, the required minimum distribution amount must be satisfied first. It has to be taken and pocketed, and then the balance or any amount left in their traditional IRA could be converted to a Roth IRA. So with the fact that required distributions in 2020 have been waived, a traditional IRA owner doesn't need to worry about taking a mandatory distribution prior to doing a conversion of any amount. So certainly an advantage to that individual. In either case, the money is going to be taxed, whether they take it as a distribution or they convert it, but the benefit being they'll be able to sock more money away into their Roth IRA if they want to convert in 2020.
So I got to have significant personal gain for those individuals taking advantage of that. Granted, you're going to have to pay attention to the tax table, but there is an opportunity for that.
Absolutely. You know, I've been in this business since Roth IRAs have been available, and I believe they were passed as part of the Tax Act back in 1998, Taxpayer Relief Act, if I recall correctly. Anyway, the bottom line is a lot of individuals did convert, you know, the first few years Roth IRAs existed, but there are people that are still continuing to convert, and we get a lot of questions on our consulting line as, again, that segment of our population, the baby boomers, has started reaching retirement age. They're thinking about how to preserve money in their IRA for their heirs. And what better way to do it than potentially convert to a Roth IRA? The IRA owner pays the taxes, and then they designate the IRA to a beneficiary upon their death.
That makes a lot of sense. So tell me more. What else applies to the CARES Act in 2020 that an individual can take advantage of?
I guess we absolutely can't ignore the COVID-19 or the pandemic. You know, Congress wrote in a provision that allows an IRA owner to take a coronavirus-related distribution from, you know, an IRA. Again, this applies to an IRA owner, not a beneficiary.
So this means that if you were in financial distress and you had a retirement account, you have another avenue that they're opening up to kind of provide relief.
Essentially, yes. In the world of retirement plans, as I'm sure you know, Samir, if an individual is younger than age 59 and a half, if they take a distribution from their retirement plan or from an IRA, the taxable portion is subject to an additional 10% penalty tax. It just seems logical that 10% penalty tax exists to discourage people from tapping into their retirement plans too early in life. But at age 59 and a half, that penalty tax goes away. Now, there are several reasons an individual can take distributions from their IRA before 59 and a half and avoid that 10% additional tax. You know, disability is one, higher educational expenses. As you heard me mention earlier, a new provision under the Secure Act for birth and adoption expenses, and now under the CARES Act, a coronavirus-related distribution, but only if an individual, it can be taken only by an individual who has been directly affected by the virus. Examples being they've been diagnosed with the virus or whose spouse or dependents have been diagnosed, or as a result of the virus, they face, like I believe you said, financial difficulty. Earlier this year, by the way, the IRS did release Notice 2020-50, which does provide some really pretty good guidance on this provision.
Are these distributions repayable without penalty as well?
Another really good question. Absolutely. The tax law has a provision written in there, the CARES Act, where if an individual chooses, they can redeposit that distribution over a 3-year period. So, now it's a case where if somebody takes advantage of redepositing that money, they would likely need to amend previous year tax returns to collect any taxes that they paid on the original distribution. So if they don't pay the money back, they were able to take it without incurring the 10% penalty tax. But if they do pay it back, they have a 3-year period to do so.
And does that put an extra burden then on the banks that hold those accounts? I mean, first thing, it's the writing's on the wall. Take the money if you really, really need it. But note, if you plan to repay some of it because you don't use it, it's a big tax burden, right? You're going to have to do a lot of paperwork, file it in the right way. There may be multiple years of tax amendments. How about on the bank side of that? Will they have to file on behalf of their clients as well?
The only thing a financial institution or an IRA custodian or trustee is going to have to do is report the deposit back, or the repayment as the tax law calls it. And with the CARES Act being a piece of legislation that took place, in 2020, it's effective for 2020. We have to wait and see, how the IRS wants the repayments reported on a 5498. And those 2020 reporting instructions, will likely shed some more light on that when they come out.
So let's say you're an IRA trustee with both of these acts that you've explained to us in mind. What should we be doing to make sure that the IRA program complies with all of these changes?
Many smaller financial organizations that offer IRAs are challenged with staying in front of the rules and regulations, and they often overlook their complexity and the impact that rule changes have on operating systems, as your question was earlier. And for that matter, their procedures and transaction documents, should all likely be reviewed. So in an effort to maintain compliance, an organization, should definitely be in tune with rules. They need to have that comfort level to confidently work with their IRA owners and beneficiaries. So knowing, when to answer questions as an IRA trustee versus when, for example, not to answer questions because it might cross the line of giving tax advice. They need to know when to send their customer to their accountant or attorney. So, and the thing that I think organizations should really keep in mind, Samir, is the fact that when dealing with IRA owners, it is in many cases a case where they're probably dealing with that individual's single largest asset. And the trust that an individual places in their custodian or trustee is significant. So, it's important that organizations be aware of the rules. They be on top of the rules. They take the time to educate their staff. I think it's simply a case where organizations are going to continue seeing their portfolios, their IRA portfolios balances increase and get larger as, again, we have more people retiring.
So in your day-to-day work, what are the observations that you're seeing as both individuals and institutions need to make changes regarding both of these acts?
Well, as far as the changes that they need to make, I believe the biggest thing that they need to be astute of is again, keeping in mind that the changes can have a significant effect on their IRA owners. So organizations should be aware of the fact that if a traditional IRA owner who is 70 and a half or older now wants to make a contribution to his or her IRA, they can do so, considering the financial organization amend their IRA agreement. And I'm going to mention that here in just a minute too. But, the other thing that's important is organizations need to be aware of the fact that, again, as I mentioned earlier, the required minimum distribution starting point for traditional IRA owners has been moved back to age 72. And really, to answer your question, is it really comes down to education, being aware of the rules and letting your staff know that these rules have changed. And when their IRA owners come in to ask questions, or beneficiaries of IRA owners, when they come in to ask questions, they're not intimidated by the question. They have the confidence level to answer that question. And quite frankly, the best way to find that confidence level is by education and reading and being aware of what is in the IRA documents and how they work, reading the instructions in those documents.
So let's talk about those documents a little bit further. You referenced them a few times, and what more is there to know? And what does Wolters Kluwer in your day-to-day actually advise?
Sure. So, again, with the significance of these two tax acts that we've highlighted today, the Secure Act passing in December of last year and then the CARES Act in March of this year, the Tax Advantage Accounts consulting team was extremely busy updating all of our ancillary transactional documents. It was a huge undertaking to get everything updated, provided to our forms partners, making them available for IRA custodians and trustees to access. However, when we talk about the IRA plan document, the establishment document, which essentially becomes a legal contractual agreement once an IRA owner establishes that IRA, we can't update that automatically right away because our documents are based on what is called an IRS model agreement. So the IRS has model agreements for traditional IRAs and for Roth IRAs. They have a custodial version and they have a trust version. So the IRS finally, on September 2nd, did release Notice 2020-68, and it does provide in the form of questions and answers some of the concerns regarding some of the specific provisions on the Secure Act anyway, and the Bipartisan American Minors Act of 2019. So, and this is what I referenced earlier. I believe I mentioned that. I'd come back to this. The notice clearly indicates that the post-age 70.5 traditional IRA contribution provision of the Secure Act, can be taken advantage of by a financial organization if they want to. They're not required to accept post-70.5 contributions, though. However, they can, again, choose to accept them.
So if I'm a 70.5 age individual and I've got a longstanding IRA with a financial institution, I haven't received a new quote-unquote contract for the account and how the account is managed. I just know that, right? And if I'm paying attention to the legislation and I know that something has changed, what are my options?
So in some cases, an IRA owner, and we get these calls on our consulting service on occasion, IRA owners will hear something before a financial institution does. So a financial organization may be in a position where an IRA owner who's age 71 or 72 or whatever the case is, they're 75, they come in and they'd like to make a traditional IRA contribution. And the financial organization isn't aware of the rule change, and they say, well, you can't do that. Well, that rule has again changed. But there's one caveat to that. This Notice 2020-68 that I mentioned, in it, the IRS states that an organization, again, as I said, does not have to accept these contributions by individuals 70.5 or older. But if they choose to, the notice states, and I quote, the IRA custodian trustee is required to send an amendment and a new disclosure statement to each existing IRA owner regarding the acceptance of post-70.5 contributions. Furthermore, IRA custodians and trustees must deliver copies of the amendment to IRA owners no later than the 30th day after the later of the date on which the amendment is adopted or the date that the amendment becomes effective. So, essentially, for an organization to allow traditional IRA owners to make contributions in their 70.5 year or subsequent year, looks like the amendment is required.
That is an interesting situation that is almost tough to navigate. Just to make sure I understand it right, financial institutions can market to individuals to open new accounts so they can continue to contribute to their IRAs and other tax advantage accounts. For the bank, this increases their own capital ratios and strengthens their balance sheet.
Getting the competitive edge because we'll allow contributions upon attainment of age 70.5 and your current custodian might not. Interesting viewpoint. I can see that happening actually, with some institutions who, aggressively market their IRA program. Again, if an organization wants to expand its IRA portfolio, there are definitely opportunities. And we do on our consulting line too, again, take calls where IRA owners are interested in contributing to their IRA upon attainment of 70.5, but under the old rule, they couldn't. Now they'll be able to, as long as the financial organization acting as custodian or trustee takes the appropriate steps allowing for it.
Yeah, I just see that this could become a major and significant balance sheet play from a very strategic standpoint of larger institutions, right? They want to deploy funds in a good way into the economy to stimulate it, but it takes, precise navigation and strategy between all the different types of accounts on the ledger. And this just is another one of those types of accounts. And as I hear more information from you on this, if I was running a bank, it's something that would be on my radar.
Samir, the bottom line is, as I said a few minutes ago, When financial organizations are working with their IRA owners, in many cases, they're dealing with their IRA owner's single biggest asset. As we see our population aging and those people retiring who have worked for a company for, a decade, 2 or maybe 3 decades or maybe more, they roll over their employer plan, 401k, profit sharing, pension, whatever. We're not talking $10,000 or $20,000 rollovers. We're talking rollovers into the hundreds of thousands of dollars or, north of $1 million or more. And financial organizations, again, if they are going to administer these accounts, again, it's critical that they be aware of the rules so they're taking care of their customers.
Are there regulations limiting how much of these funds can be transferred at a bank state as opposed to the individual? Or is this really, hey, it's freedom of choice for the client?
Yeah, it really is freedom of choice, with obviously the biggest thing in mind, FDIC insurance, because IRAs are covered, the investment rather in an IRA might, or in some cases is not covered by FDIC insurance. Certainly a certificate of deposit held in an IRA is covered, a savings plan under an IRA is covered, but self-directed types of investments, like mutual funds and securities, might not be. We don't really get into the FDIC insurance coverage discussion too much, but in any event, again, to answer your question is, there really isn't a limit as to the amount an individual can move to an IRA at a financial organization. It's just, what type of insurance coverage and diversification and, those types of things do they want to take advantage of.
Let's say an institution goes forward and wants to notify all their clients and give them notices. What other steps need to be taken in order to make sure that these changes take place?
Notice 2020-68 really only addresses that one legislative change, the post 70.5 contributions. It doesn't really address the later age at which somebody can start taking required distributions and, those other things. So the notice, I shouldn't say it doesn't address those things. It doesn't specifically address those things. One thing the notice does say, though, is that the deadline for financial organizations to amend the document governing an IRA for the provisions of the Secure Act or regulations thereunder is December 31st, 2022, or such later date as prescribed by the Secretary in guidance. So, Wolters Kluwer is going to carefully watch for the IRS to update its 5305 model documents so we can update our documents that the model documents are based on. Of course, we are updating our 4-page disclosure statement that is contained as part of the IRA organizer, which is the Wolters Kluwer document. So the disclosure statement is going to encapsulate all of the changes that have taken place. And of course, we're waiting for the IRS to release its cost of living adjustments in October here. And we'll write those in. But, one of the things that, again, I do want to point out is the IRS hasn't updated the model documents, the 5305s. That might sound a little confusing, so let me explain just a little bit more. When an organization establishes an IRA, the rules require they provide the individual with a model document and a plain language disclosure statement, which includes a financial disclosure. So like I said, the IRS hasn't updated the model document yet, but we are updating our disclosure statement. So in a sense, part of the Wolters Kluwer organizer, the establishment document, will reflect the new rules.
It's almost like 2 updates need to take place, even if you are, if you're a client of Wolters Kluwer or a client of another administrator of these documents, it looks like 2 updates and you better anticipate those.
Yeah, so when we analyze that just a little bit more, again, we need to look at, number one, IRS Notice 2020-68 and what it says, for organizations to accept post-age 70.5 contributions. An amendment to the agreement is necessary. So we'll have the document, the plain language disclosure available this fall in order for organizations to allow that. But again, the rest of the provisions, are not necessarily going to be available to incorporate until, like I said, the IRS updates its model document, or at least we won't have that model document to provide as part of the IRA organizer and an amendment until the IRS is done with its share.
Are there any other things that our listeners may want to know as it relates to the IRAs?
As far as required distributions go, there is one interesting thing because it will be far-reaching. As our population has aged and life expectancy, changes over the years, the IRS has been tasked, so to speak, with updating the life expectancy divisors, which are, included on a series of life expectancy tables. The last time they updated these life expectancy tables, Samir, was in 2002. So actually, I think it was 2001, effective for 2002 perhaps. But in any event, the IRS has released a proposed regulation which includes the updated life expectancy divisors. But they have not yet indicated when those life expectancy divisors are going to be effective for calculating required distributions. It's likely it could be 2021, but, we're within 3 months of that now. So with everything going on in 2020, though, there is obviously the possibility that they could push the effective date for the new life expectancy tables out to 2022. And the reason I say that's going to be a far-reaching issue is because organizations in many cases have software that do calculate distributions for account owners and beneficiaries. And with a series of 3 tables and multiple life expectancy divisors on each table, it could require a lot of data system programming.
That makes a lot of sense. I still can't believe it's 18 years old, going on basically 20 years to be an update. I would have expected it to update with the census. Mike, it's been a pleasure speaking with you, and I can tell you I have learned a tremendous amount just in our short conversation around this topic. I hope that other listeners have also taken that back and seen the benefit of paying attention to this, and potentially even for their larger cohorts in their business of building a strategy around tax advantage accounts. So thank you, and I look forward to our next conversation in the future.
Thank you, Samir. It's been a pleasure discussing IRAs and a lot of the changes that have taken place, and I as well am looking forward to our next opportunity to discuss other rules and regulations.
Greg, let me turn things back over to you.
That's Wolters Kluwer Vice President for Banking Compliance Solutions, Samir Agarwal, joined by Michael Schiller, Manager of Specialized Consulting in the Tax Advantaged Accounts area. Wolters Kluwer is the host of this podcast and a market-leading provider of advisory services and technology solutions for optimizing compliance and risk management programs. For more information and additional guidance, please visit wolterskluwer.com or call 1-800-397-2341. Please join us for future podcasts focused on navigating emerging trends in regulatory compliance.